Have you ever pondered over the role of criminal law in maintaining social order? The essence of criminal law lies not just in punishing wrongdoers, but also in establishing an orderly society where rights are respected and peace prevails. Today, we journey through the history and development of the Pakistan Penal Code, a significant pillar of Pakistan's criminal justice system. In the mid-19th century, during British colonial rule, the Pakistan Penal Code was brought to life. It was the year 1860, a time when the subcontinent was under the firm grip of the British Empire. The introduction of the Pakistan Penal Code marked a significant shift in the legal landscape, outlining criminal offences, their definitions and corresponding penalties in a comprehensive legal document. As Pakistan gained independence from British rule on the 14th of August 1947, the Pakistan Penal Code was adopted as part of the country's legal system. This marked the commencement of a legal framework designed to uphold law and order, protect individual rights, and ensure public safety. It was a cornerstone paving the way for a consistent approach to criminal justice across the newly formed nation. The scope of the Pakistan Penal Code is vast, covering a wide spectrum of criminal offences, from crimes against individuals such as murder and assault to offences against property, public order, and the state. The code offers a robust framework for assessing criminal behaviour and determining legal liability. Known by its short title, Pakistan Penal Code, or PPC, this legal document's provisions apply throughout Pakistan. This includes all provinces, territories and regions under federal jurisdiction, ensuring uniformity and consistency in the administration of criminal justice. Over the years, the PPC has evolved, undergoing amendments and modifications to reflect societal norms and legal standards. The interpretation of the Pakistan Penal Code involves understanding the definitions of various criminal offences, the elements required to establish culpability, and the procedures for the investigation, prosecution, and trial of criminal cases. Legal experts and courts interpret the provisions of the PPC in accordance with established legal principles, precedents, and the overarching objectives of justice and equity. In summary, the Pakistan Penal Code, born in the era of British colonial rule, has grown to become an integral part of Pakistan's criminal justice system. Its primary purpose is to define criminal conduct, establish punishments for offences, and provide procedural guidelines for the investigation, prosecution, and adjudication of criminal cases. It serves to uphold law and order, protect individual rights, ensure public safety, and maintain social harmony within Pakistani society. A true testament to the power of criminal law in shaping an order. Welcome to an enlightening journey through the complexities of the Code, a comprehensive set of legal guidelines that governs how we interpret and apply law. This video will provide a brief context of each chapter and section, guiding you through an intricate labyrinth of legal principles and stipulations. Our journey begins with Chapter 1, Introduction. Here we delve into the fundamentals, the title and extent of operation of the Code. This section sets the stage for the entire Code, establishing its jurisdiction and the scope of its application. Next, we tackle the issue of punishing offenses committed within the borders of Pakistan. The Code is clear and unambiguous on this point, affirming the nation's right to uphold its laws and punish offenders. The third section broadens the scope, dealing with offenses committed beyond Pakistan's borders, but which by law may still be tried within the country. This allows for the extension of justice, even when crimes cross geographical boundaries. Section 4 takes this concept further, outlining the extension of the Code on extraterritorial offenses. Here, the Code transcends geographical limitations, ensuring that justice is upheld, regardless of where an offense takes place. Closing out the first chapter, Section 5 asserts that certain laws will not be affected by this act. This ensures that the Code does not override or conflict with existing laws that are outside its purview. Moving on to Chapter 2, we explore general explanations. This chapter, spanning from Section 6 to 52A, provides the definitions and interpretations necessary for understanding the rest of the Code. These explanations serve as the backbone of the Code, clarifying terms and concepts to ensure uniform understanding and application. Chapter 3, titled Of Punishments, takes us from Section 53 to 75. This chapter meticulously details the various forms of punishments that can be meted out under the code. It serves as a guide to the consequences of violating the law, setting clear expectations for potential offenders and the justice system alike. Chapter 4 presents general exceptions, encompassing sections 76 to 106. This chapter is crucial as it outlines the exceptions to the rules, the circumstances under which individuals may be exempt from punishment under the code. It ensures balance and fairness in the application of law. Lastly, Chapter 5 discusses of abatement, extending from section 107 to 120. This chapter addresses those who may not commit an offense but play a part in its commission. It underscores the code's commitment to comprehensive justice, holding all parties involved in an offense accountable.
Diving into the heart of the matter, we begin with Chapter 5A, dealing with the concept of criminal conspiracy. Section 120A lays the foundation, defining what constitutes a criminal conspiracy. This is followed by Section 120B, which deals with the punishment for engaging in such conspiracies. This chapter provides a lens to view collective criminal actions and their repercussions. Moving on, Chapter 6 focuses on offenses against the state. It commences with Section 121, which discusses waging or attempting to wage war against the state, and ends with Section 130, covering aid to prisoners of war. This chapter emphasizes the gravity of crimes against the state and their potential impact on national security. Next, Chapter 7 delves into offenses relating to the Army, Navy, and Air Force. From Section 131, which talks about abetting mutiny, to Section 140, addressing wearing soldiers' garb unlawfully. This chapter highlights the severe punishment for crimes against the military. Chapter 8, meanwhile, discusses offenses against public tranquility, starting with Section 141, defining unlawful assembly, and concluding with Section 160, detailing the punishment for committing an affray. The chapter underscores the importance of maintaining peace and harmony in society. In Chapter 9, we examine offenses by or relating to public servants. It begins with Section 161, discussing public servant taking a bribe, and concludes with Section 171, outlining wearing garb, or carrying a token used by a public servant with fraudulent intent. This chapter underscores the responsibility and accountability of public servants. Chapter 9A is all about offenses relating to elections. It starts with Section 171A, which deals with the offense of bribery in elections, and ends with Section 171J, which discusses the penalty for illegal payments. This chapter underlines the importance of fair and transparent electoral processes. Finally, Chapter 10 focuses on contempts of the lawful authority of public servants. From Section 172, which discusses the absence from duty without permission, to Section 190, dealing with the threat of injury to a public servant, this chapter emphasizes the importance of respecting the lawful authority of public servants. Have you ever contemplated how the seemingly mundane aspects of our lives, like weights and measures, or the coins in our pockets, are intrinsically tied to the fabric of our justice system? Today, we're going to delve into an understanding of these connections and how they impact public justice. Imagine a world where the value of currency was arbitrary, where a pound of apples could weigh more or less depending on the whims of the seller. This world would be chaotic, unpredictable, and ripe for exploitation. It's these potential vulnerabilities that our laws and regulations strive to address. Chapter 12 of the Legal Code, pertaining to offenses relating to coin and government stamps, plays a crucial role in ensuring economic stability. It safeguards the integrity of our currency, deterring counterfeiting and guarding against financial fraud. This not only secures our economy, but also bolsters public trust in our financial systems. Moving on to Chapter 13, we find ourselves in the world of weights and measures. Here, the law ensures the accuracy and fairness of transactions. It safeguards consumers from being shortchanged and maintains a level playing field for businesses. This is a prime example of how our legal system upholds justice in the most basic aspects of our daily lives. Chapter 14 shifts the focus to offenses affecting public health, safety, convenience, decency, and morals. This section underscores the role of the law in protecting citizens from harm, promoting public welfare, and maintaining societal norms and values. It's the legal embodiment of our collective responsibility towards each other. Finally, Chapter 15 addresses offenses relating to religion. In a diverse society, respect for religious freedom and tolerance is crucial for maintaining harmony. Our laws serve as a protective shield, guarding against religious discrimination and hate crimes, thus reinforcing the values of equality and unity. Delve into the realm of offenses relating to religion, covered in sections 295 to 298C. These laws are designed to protect the freedom of belief and practice, ensuring that every individual's right to their faith is respected. They act as a shield against religious discrimination and hate crimes, and uphold the principle of coexistence. Moving on, we explore the laws concerning offenses affecting the human body. Spanning from section 299 to 338H, these laws encompass a wide range of offenses, from assault to murder. These laws are there to protect our physical integrity and the sanctity of life, asserting that every person has the right to safety and security. Next, we delve into the sphere of wrongful restraint and confinement, with laws from section 339 to 348. These laws are in place to protect personal liberty, ensuring that no individual is unlawfully restrained or confined against their will. Sections 349 to 358 focus on criminal force and assault, laws that reinforce the principle that violence is not a means to resolve disputes. Following this, we examine the laws on kidnapping, abduction, slavery, and forced labor, from section 359 to 374. These laws emphasize the importance of personal freedom and human dignity. Sections 375 to 376B focus on the grave offense of rape, while sections 377 to 377B deal with unnatural offenses. These laws stand firm against sexual violence and exploitation, upholding the rights and dignity of all individuals. Next, we delve into theft, extortion, robbery, and hijacking, covered from section 378 to 402C. These laws are designed to protect property rights and maintain social order. Sections 403 to 414 concern criminal misappropriation of property and criminal breach of stolen property, laws that uphold justice and fairness in property matters. Cheating and fraudulent deeds, covered in sections 415 to 424, are offenses that undermine trust and honesty in society, and these laws are in place to prevent such deceitful acts. Sections 425 to 440 deal with mischief, while sections 441 to 462 focus on criminal trespass.
Delving into Chapter 18, it pertains to offenses relating to documents and to trade or property marks. This section from 463 to 477A deals with the misuse of trade, property, and other marks. It covers the fraudulent use of a mark without the consent of its rightful owner, which is considered a criminal act. In the same chapter, sections 478 to 489 discuss offenses related to currency notes and banknotes. These sections lay out the penalties for counterfeiting, altering, or knowingly using counterfeit notes, safeguarding the financial integrity of the nation. Moving ahead to Chapter 19, the focus shifts to the criminal breach of contracts of service. Sections 490 to 492 outline the responsibilities of both parties in a contract. A breach of these responsibilities can lead to criminal charges, emphasizing the importance of honoring commitments. Chapter 20, Offenses relating to marriage, ranges from section 493 to 498. It addresses issues such as bigamy, adultery, and cruelty by a husband or his relatives, providing legal protection to individuals within the institution of marriage. Chapter 20A, titled Offenses Against Women, covers sections 498A to 498C. This chapter is dedicated to protecting women from dowry-related harassment, domestic violence, and other gender-specific crimes. Chapter 21, of defamation, from section 499 to 502A, defines defamation and the penalties for such offenses. This chapter serves to uphold an individual's reputation against false statements. Chapter 22, of criminal intimidation, insult, and annoyance, spanning sections 503 to 510, addresses a range of offenses from threats and intimidation to insults and annoyance, providing a legal framework to protect individuals from psychological harm. Finally, Chapter 23, of attempts to commit offenses, is encapsulated in section 511. It lays out the principle that an attempt to commit a crime is, in itself, a crime, emphasizing the preventative aspect of law enforcement.